Good morning, Mr. Randolph.
Good morning.
So you're charged with assault, causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched to an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away, and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I was out. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
They was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
You
understand?
protect me from these kind of people.
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm
the right
running from
to
these
stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want
to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know no news. I don't know these people.
Listen, just I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. Good morning, Ms. Reyes. You were charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 25th, 2025, a law enforcement officer was dispatched regarding a DWI investigation in Harris County, Texas. The law enforcement officer who conducted the traffic stop stated he observed the motor vehicle traveling the wrong way down Commerce Street. The law enforcement officer stated to the investigating officer that he observed red glossy eyes. The other law enforcement officer arrived on scene and observed bloodshot glossy eyes. The defendant admitted to drinking small margarita sample-sized drinks. The defendant stated she did not know she was traveling the wrong way down the street. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 3 out of 4 on the one-leg stand. The defendant consented to a roadside preliminary breath test yielding a 0.12. The DIC was read, and the defendant agreed to provide a breath sample for the breath test strip reading a 0.086 and a 0.088.
Okay. Ms. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, I will put you in jail. You understand, man? Any prior DUIs?
No prior DUIs.
License?
Eligible.
Okay. You are not allowed to drive unless you have a valid license and insurance in your name. You understand? That is also a condition of your bond. I will appoint you a lawyer today. So what we'll have you do now is I'm going to have you head on over to Victoria, sign a reset. We'll have you take a seat in the jury box. I'm going to get your bond conditions, we'll have you sign it, and we'll have you speak to a lawyer here momentarily, man. Okay, please. I'll do yours after, I guess. So you are Marcus Taylor. Mr. Taylor, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance/unknown weapon call. The law enforcement officer met with the complaining witness, who stated he is an employee of the state veterans home on the nursing staff.
John Garza?
The complaining witness states that the defendant is unwelcome at the facility and has been asked to leave on multiple occasions, and the defendant has refused to do so. The complaining witness stated the defendant was attempting to have his grandfather sign power of attorney paperwork. However, nurses intervened due to the grandfather being diagnosed with dementia. The complaining witness states that the defendant used force to remove the complaining witness from the grandfather's room by pushing the complaining witness on the chest with his hands. The complaining witness stated he felt pain. The complaining witness positively ID'd the defendant. Law enforcement officers detained the defendant without incident.
Okay. Mr. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. You were also ordered as a condition not to be in possession of any weapons as well. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a recess. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go.
This is affidavit, Judge.
Okay. Please.
Your Honor, speak up loud enough for me to hear
Good
you.
morning, Mr. Melcher. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a prior DUI and they roll up to your window and they smell alcohol or dope, it's probably not going to go well for you. What we're doing today, from now on, is a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Understand?
Yes, sir.
You're giving up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want to do.
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you.
Thank you, Judge. Maybe we be excused.